was this light on the house.
Yeah, and that bothers you.
And that bothers us. I said, Mom, just take care of it tonight. That's what shotguns are for.
That's what shotguns are for, absolutely. Absolutely.
Oh no, I don't. She really does. Oh no, don't do that.
One of my great aunts or something hears a noise in the night, gets up with her shotgun, and is sure that she sees this face looking at her right from her backyard. So blows it away and goes back to bed. And the next morning,
I'll look tomorrow.
and the next morning she comes out, she'd blown out the head off her prized sunflower.
But what I loved about this story was she shoots something she thinks is a guy and just leaves it until the next morning. I go up to visit my brother and he went to a very small private college up there. And they had a street light outside of their fraternity house, and they wanted it to be a little darker. He goes, "Oh, God, we got to shoot this out." And I went, "All right." I mean, there was 5 shotguns out. I mean, there was no, "Oh, you do it, no, you do it." No,
Everybody's gonna do it. Well, it's like that story they told at Dave Moore's oil, right?
Yeah,
the
bat
Dave?
in the office.
Yep. Just go take care of it.
Yeah. So that's the nice thing about Virginia.
Yeah.
All right, have a good class.
Thank you, John.
You bet.
Appreciate it.
Yeah, I'm not doing that for Tuesday.
No, I know. I got to second up and do my job on Tuesday. I'm covered for it.
Sounds like fun.
Well, here's the problem. I went to probate school a few years ago, so I could back up Jim Cox. That was a few years ago. And what I don't remember about probate is
Don't remember.
a lot. Oh, the crowd's off. The game's
Yeah,
off.
right there. They come straight.
So everybody ready to ask leading questions this evening? Leading questions? Wasn't that what we were supposed to be doing?
Oh, yeah, I don't know. Did they read the material?
You guys read the material? All right. So you know what a leading question is? Isn't it true? You know what a leading question is? Anybody?
It can be done directly, or no, it can be done
On cross.
but not direct.
Not indirect. Unless there's a whole bunch of reasons you can do it.
Kids.
Kids,
elderly.
foundation, experts, a witness who doesn't want to say what you want him to say, otherwise known as a hostile witness. Are you related to Mr. Gambino? Yes, I'm his fiance. Well, that would explain the hostility.
Exactly.
Oh, yeah. Fun. Fun, fun, fun.
We're gonna try and keep my distance from you
You're
guys.
sick.
Oh,
You know, and I'm already to blame. Everybody who's got a sniffle at the office, gave it to us. So
the slow people.
I thought cancer wasn't contagious.
I know.
It's a joke, everybody. Now, if Professor Nolan actually turns out to have cancer, I'm going to feel really good. But I'm not liking the odds of that.
All right, I got to share with you guys because it was such a surreal moment for me. You know, these things you can't make this stuff up, right? Real life is so much better than any of the stuff you're gonna read in a book. So I'm at this hearing on Wednesday last week, and we're discussing a matter over what this hearing is basically what the term of this trust means. Right? And we say it means that our client's the trustee and they have right over the trust property and defend it near in our
That's what it
property
means.
and get the hell out. You know, they're trying to interpret the meaning in another way. The judge is kind of going my way, asked the defense, well, why isn't Mr. Nolan's analysis correct?
Yeah.
And the response was, well, anybody who's been to law school knows that's not what that means. And the judge kind of sat up in his chair. I can assure you I've been to law school and I don't read it that way. Oops. So
Yeah, it's,
It's a bit of a problem.
and that's when I leaned over to my client, okay, shh, we say nothing, smile, smile, we sit here and smile and we say nothing, we're done here. And this gal, brand new lawyer, she was out from LA, had just got sworn in December, so she's been a lawyer all of about half a year. And don't do that. Right? Don't insult the judge when you're in a hearing.
Or any other time.
Yeah, that's just not going to get you too far. So give them your authority, give them your basis for why they should do what you're asking them to do. And if they disagree with you, don't start counting and calling them names.
That's a very bad
That's
word.
not going to get you anywhere. So, but it's funny. Everybody, shared that back at the firm. And
Yeah, I got a good
she
laugh
didn't
out of
really
it.
say that, did she? Yeah, she did.
A very good laugh out of that.
So,
What happened in the case?
her client got booted off the property.
Boom.
So,
Good.
yeah, it was great. He got all agitated. He started jumping up and trying to talk to the judge, and her trying to kind of just settle down. The judge says, "Sir, you need to sit down." And the deputy comes over and stands by him, and
That's always not a good. That's not a good thing. If the deputy comes over and stands by you in court, whatever you're doing, stop.
so it was an exciting, what should have been an uneventful hearing, turned out to be an exciting one. And I got another story to share with the classes.
There you go.
Here's what you don't do.
So what do you do?
All right, we are on to, we had a heavy reading load this week, guys, right? Heavy reading load. So hopefully you all were able to get through it and make some sense of it. We've got 2 subsections we're going through tonight, and I hope you guys can appreciate why we're doing this, why we're spending so much time on this on the front end. The rules are coming. And once you get the rules, you just got to know them and start applying them. But if you're not able to understand how you apply them, when you apply them, in what circumstances you apply them, it doesn't do any good to know the rules. That's why we focus so much on understanding the trial procedure, the objection procedure, and now you're going to get into some practice on using that and understanding what type of objections are there. These are just basic objections that aren't even rule related. Okay, you'll get into rule related objections, right, when you learn the rules. But these are just basic objections that you have to have an understanding of what they mean and how to apply them, and then you'll be able to start utilizing them when we're giving you fact patterns and asking you to do that. Okay, so 611, sub A. Okay, mode and order of examining witnesses and presenting evidence. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth, avoid wasting time, and protect witnesses from harassment or undue embarrassment. Okay, so that gives a lot of discretion to the court, not only in the order of how you're calling your witnesses, but also in the mode. Okay, which means how you go about doing that. Right? And sometimes the court might let you lead on direct. Right? Sometimes the court might grant you the ability to do things with certain witnesses that normally you can't. Okay, and provided you can give the court a basis that's based on one of these 3 things, right? We're searching for the truth, we're not wasting time, and we're protecting our witnesses from harassment and undue embarrassment,
then there you go. Okay, C, leading questions should not be used on direct examination except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading witnesses on cross-examination and when a party calls a hostile witness an adverse party or a witness identified with an adverse party. Okay, so there's a whole foundation that will need to be laid before somebody can be declared hostile. But assuming you get through that and the court does declare them hostile, then you can lead your own witness that you call to the stand. Okay? One of the more recent times that I was able to have a hostile witness, I had a defendant that was on trial, and I wanted to call his sister. Here's a witness. I knew the sister wasn't going to give me anything. But it didn't matter what she gave me because she had already talked to the police when her brother weren't friends. So she had ratted her brother out to the police. And at that point, it really didn't matter what she said to me because I could always call the police to impeach her if she didn't stay.
If a witness has made we're not covering it today, but if a witness has made a statement before that kind of contradicts something the witness says on the witness stand, you can introduce it. Not just introduce it to impeach them, but as evidence that that prior statement was true.
Yeah, so this particular witness turned out to be one of my funner witnesses. She just wasn't cooperating. She wasn't answering any of my questions. I asked the court to have her declared hostile, and the court granted it, and I got to lead, which means, in essence, I got to put the words I wanted in her mouth, and all she could do was say yes,
Yes,
or no.
no.
Yes or no. And I was able to effectively paint such a picture that she got so upset, so frustrated, that she got up off the witness stand, said, "I'm done with this shit," and walked right out the court. Jury sitting in the box.
We'll just write all that witness's testimony.
Judges on the bench, and that's what they were. I didn't have a client, but I was like, "Shh, that's good for us. Don't say anything." that's good for us. That helps. And not like she was done. She threw her little fit and she walked out the courtroom, and court deputy got her and brought her back to the witness stand, and she was more angry and more frustrated and more hostile, and basically I got to testify. But it didn't, at that point, it didn't even matter what her yes or no's were, because I'm telling the story by leading her with my questions. I'm asserting all these facts. She's grumbling, and no. I'm asserting them, and no, and I'm asserting them, and no. And, basically the picture that's being painted in the juror's mind is what I'm painting, not the one the witness is painting. But what the witness is doing by being hostile is basically affirming that what I'm saying is true. Okay? And that is really the way it works. One of he was a good defense attorney. There was a local defense attorney. He's passed, so he's not currently practicing, who had a similar such issue. I had called a friend of the defendants to the witness stand, and he was hostile. He wasn't answering any of my questions. And when I was done with him, the defense attorney stood up and said, "Do you want your friend to go to prison? Do you think any of this you just did is helping him? Standing up here, not answering questions? You're making it worse for him. Why don't you try telling the truth?" Right? So he tried to minimize it and help his client by calling out what all the jury was thinking. And I'm thinking, not a bad strategy, right? Calling this guy out, knock it off. Just answer the questions, tell the truth. You're not helping my client by doing this. And didn't help his client ultimately, but I think it was about as effective a strategy as you could do in that situation. So just know that there are times when you do get to leave, provided the court grants you permission. So this is one of those situations where don't just start leaving, ask the court's permission. Your Honor, I'd like to have the court declare this witness as hostile. I'd like to have them permission to leave, and let the court grant you permission before you start doing that. Okay. Otherwise, the court could slap you down. You're not the judge who said this witness was hostile. I haven't made that determination yet. So. Let's go back to the chapter and let's talk a little bit about the sequential order, right? You get to direct your own witnesses, you call them. As a general rule, you're asking them open-ended questions and they're telling their story, right? And you can probably get away with asking certain leading questions for foundational type stuff. If you're dealing with children, or you're talking about preliminary matters, or
an elderly person, or something.
Things like that. Okay, you could probably get away with it, right? That's one of those things that the jury's not going to like. It's like, oh, you're from San Francisco. Objection leading. Okay, where are you from? San Francisco. The jury says, really, why are you? It's coming in. It's not that big a deal. So just know that you can use those sorts of things. And there's cross-examination. Okay. And then there's redirect, which is supposed to be new and different than your original direct. Attorneys screw that up all the time, right? You got your direct. Ideally, this is your witness. You're proving your case. You've asked everything of this witness you need to ask, right? Or else you should have still been asking them questions. You've asked them everything you want to ask. The other side gets to cross. When it comes to redirect, it should be a much limited portion of information that you want to question them on. Maybe issues came up during cross-examination, but it's not going to be everything you wanted to talk to them at first. You'd be surprised how many lawyers think, oh, well, let's redirect. Let me re-emphasize all of the things I talked to you about the first time. It's not what redirect is about. Okay, you're not supposed to go over those stuff you've already gone over. It's supposed to be limited to maybe issues that were raised on cross-examination. And then recross is the same thing. They're only supposed to be crossing on your limited redirect. They're supposed to be crossing on your limited recross, and attorneys just think it's an open door to just do whatever the hell they want. It's not. This is one of those areas where I've seen in my experience where the courts get involved more than the other attorney does. Where the court will say, counsel, we've already gone over this. This is redirect. Go to something new. Rather than the other side objecting. Okay, so that being said, as the testimony comes out, there are a wide variety of objections that can be made, and that's what this little section talks about. And understanding what those objections are helps you maintain control of the witnesses, the questions, and the answers. Okay, remember, like we said last week, evidence comes in, one question at a time, one answer at a time, one item at a time, so you should be objecting accordingly. If you got an objection to the question, you should be objecting at the question. The answer to the answer, to the item to the item. The first objection they talk about is leading questions. All right, leading questions are questions that suggest an answer. They suggest facts, right? And it's a common preface that that attorneys will use. They'll say, isn't it true? Right? And a little trick that they'll do is they'll say, isn't it true, probably about 3 or 4 times. Right? Isn't it true that you were driving your car down Indio Boulevard on this date? Yes. And isn't it true that it was dark that night? Yes. And isn't it true that it was raining that night? And you were drinking that night too, right? And then all of a sudden you're making statements and they're like, yes, yes, no, yes. And you're not even asking a question at some point. It's a little tactic. Sometimes the other side will catch on. You're on objection counsel's not asking a question, and you go back, right? Isn't it true? Isn't it true? And what'll happen is you'll get into a rhythm, and then you start posing statements to them, and they just answer them. Right, but ideally what you're doing is you are suggesting a fact and getting them to accept it or reject it, okay? And a lot of times they could be all no, right? You'll see some cross-examination that they're just asking questions to paint a story, and your witness is saying no, 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 and the attorney sits down and the jury has this picture in their mind of this event that transpired, and the witness has said no to all of it, right? But by way of questioning, it was suggested that things happened a certain way. Okay, that's why it's such an effective tool to use on cross-examination, because it allows you to really challenge what the witness is saying, while at the same time painting a picture, suggesting alternative facts that juries remember. They don't necessarily remember what the witness has said. So whose job is it to remind them of that? If you're on the other side, that's your job. Right? So in closing argument, when the defense says, here's what really happened, A, B, C, D, E, and F, who testified to that? Right? No witness did. Counsel testified to that. He said all that by his questions, but remember, all those answers to that were no. No witness ever came in and said that. So remember when you can use leading questions and under what parameters. Asked and answered?
Never say asked and answered. What's the correct objection then? But cumulative. It's already in evidence. So I'm a nut about this. If you are in 3R and you object asked and answered, I will ask you, what do you mean by that? And you will come against cumulative. You're right.
Okay, and that's one of those things too that on direct examination it makes sense, right? You've asked the question, they've already answered the question. No need to ask it again and go over it again. You've already got that evidence in front of the jury. On cross-examination though, they give you a little more leeway, right? And they'll allow you to ask the question more times than once, right? Because you're supposedly sifting for the truth, right? And so maybe they deny it the first time, maybe they deny it the second time, and then you ask it a slightly different way, and you catch them. They admit that they knew it. So on cross-examination, you're generally given more leeway and asking the same question more than once and in different ways. Okay. 3 compound questions. Right, those are questions that actually are 2 or more questions. Okay, that's common. You'll get lawyers that are really good. They'll get 3, 4, 5 questions in there, and you've never had. Right? What's the question? Right? It's got to be one question, one answer at a time. Okay, and If there's more than one, it's objection compound. Sometimes they'll ask more than one, and if you don't object, the witness will answer, and they'll only answer one of them. And then one of the questions is hanging out there, they didn't even answer it. So if it's a big deal, object. You know, I never like to object a lot in trial, so some of this stuff, you ask two questions, doesn't bug me. Right? I wasn't gonna object just to object, to be a stickler, but it is an objection, and you can use it when it's there. Questions that assume facts that are not in evidence. Questions that assume the existence of facts not yet testified to by a witness or otherwise introduced into evidence. You know, sometimes you're asking that. You know, I always like when you ask the question, right? You're from San Francisco, right? Objection assumes facts not in evidence. Well, because the witness hasn't testified that they're from San Francisco. But if they answer the question, it'll be in evidence. But that's one of those things too. It's an objection. And it can be effective, particularly on cross-examination, right? If they're putting forth this story and laying these facts out there by way of their leading questions, and they're assuming things that aren't in evidence, that can be a good objection to kind of cut that story short. So if the questions are asking about facts that nobody has testified to, that is a proper objection. Argumentative questions that are phrased in such a way that they don't seek information, but rather they merely engage the witness in proper argument. You know, that's a borderline type objection. Usually, you know, either the question has substance and merit to it or it doesn't, and the tone you're asking it to, the jury's already saw that. So having them change the tone in which they've asked the question doesn't necessarily get you much, but it's there. Don't ever object argumentative when you're in closing argument. I've seen it. The other side's giving their argument, and the other side objects. So it's argumentative. It's kind of the point. Questions that call for speculation. Right, you're asking for information beyond the witness's personal knowledge, or asking a witness to provide an inadmissible opinion. Right, if it calls for speculation, you know, my client didn't want to hurt anybody, did he? How do you know? The witness doesn't know if he wanted to hurt anybody. Can't jump inside somebody's head and answer that. So if it's not something that they know from their own personal knowledge, object to it. Non-responsive answers. Right? There are witnesses that don't respond to your specific question. Right? This is very common, right? If you're asking a hostile witness or you're questioning witnesses from the other side. Right? You ask them a question, even a leading question, and they're going to tell you something else. Right? Isn't it true that you saw the defendant hit the victim over the head with a baseball bat? Well, I went to church with the defendant, and he's a great guy, and we had the catechism together, and he wouldn't hurt a fly. Okay, my question was, you saw him hit the victim over the head with a bat, right? Well, I know his whole family. They're a great family. I've never seen any of them in trouble. Okay, you know. You saw the defendant hit the victim over the head with a bat. Well, the victim punched the defendant. Okay, but that's not my question. Did you see it? And one of one of the ways that you counteract that is I just call them on it, right? Just call them on it right there in front of the jury. Mr. Smith, I understand you came to court today with a story you wanted to tell. You've had your chance to tell that story. Now I'm just asking you to answer my questions, right? And
How would you object that if you're the one asking the question?
non-responsive. They're not answering your question. They're being non-responsive to what the question is.
So the lawyer
And you
that-
would what? Move to strike the answer.
So the lawyer that's asking the question
Sure.
objects?
Sure.
Yeah.
If they're not answering, it's non-responsive, move to strike. Right? And that's common, right? People come to court with an idea, I'm going to say these things, right? Because they know what they're coming, they know whose side they're coming to testify for, and they come to court and they have an idea these are things they're gonna say. And some of them don't care what you ask, right? They're gonna answer those questions the way they wanna answer them, so they get that story out. Nothing wrong with calling them on it, in front of the jury. I understand that's what you wanna say, but that's not what my question is. Did you understand my question? Yes. Okay, could you answer my question? And they go off again. And that's great for you, right? People worry about that, in my opinion, unnecessarily. That's great if you got a witness that won't answer your questions, they just want to say something. How hard is that for the jury to conclude that that person came in there with an agenda and they were going to say what they wanted to say regardless? I think it's easy to dismiss them at that point. And the last one there is narrative answers. Answers by witnesses that exceed the scope of the question put to them. Right? A party may object to a vague or overbroad question that would likely result in an objectionable answer. In that case, the objection would be phrased as calls for narrative. So if your question is too open-ended, right, you can't answer it in a sentence or two. You can object if the question calls for a narrative, or you just object to narrative because the witness is just going on and on and on and on. I guess you could object to your own witnesses. I never did. If my witnesses are talking and they're telling their story and the other side's letting them go, and they tell their story. And I had, and I understand why they did it, but I had one case with, it was a death penalty case. And in the penalty phase, you get to put on victim impact statements and victim impact evidence. And I called my victim's mother to the stand and I asked her maybe 2 or 3 questions, and she just started talking and talking and talking. And I didn't ask another question. And the other side didn't object. Right? You're gonna object to the witness's mother. And probably about 6 or 7 minutes later, she finished talking. Complete narrative. Okay, I have no further questions. And we were done. And the other side is like, that was narrative. I'm like, yeah, I know. And I know you did. And, I appreciate you not objecting. She was, right, because of the emotional state she was in, it wasn't going to come across good objecting. So everybody just kind of let her say what she had to say and moved on to the next witness. Just to show you, it's not all, adversarial. They came to me and they're part of the case. And they said, hey, we're going to stick our mom up on our defendant's mom on the stand. He's very protective of her. So if you go after her, you will probably get a rise out of our client and he will act out in front of the jury and just letting you know. And when the mom testified, I didn't even ask her any questions. Right? I had that information. I could have used it to my benefit to try to get an action out of the defendant, but They were gentlemen attorneys. They were showing kindness and consideration to the victim to the mother of my victim. And I wasn't going to take advantage of the mother of the defendant because they had shared that. Okay. So it's okay for lawyers to work together and trying to present their respective sides to the court. There's nothing wrong with that. And when you're going up against good counsel on the other side, it makes it easy. There's other attorneys that fight you on every little thing, and your gut is going to be, why am I going to give you anything? So just know that those things are there. My advice with regards to the objecting would be, if it helps your case, object. If it's a minor thing and it's not really helping your case and you're just doing it to prove a point, hey, I know the law and you made a mistake, it's not moving your case forward, what are you gaining out of it? Okay? If it's a big issue, absolutely object and make sure your record's clear on that. If it's not, generally just objecting to object doesn't help you out a whole lot. Okay? Know these objections. They're there. Know them. None of those have to do with any of the rules we're going to cover. So just appreciate that, right? Those are all the types of objections that you can have. So before we get into the witness strategy, why don't we go over our outline, and then we'll go through some of the examples there, and you can see how this actually starts playing out. Okay. What the basic procedural principle we've already talked about. One question, one answer. Right? The attorney is supposed to ask a question, not make a statement. For example, if the attorney makes a remark such as, "That's very odd considering it was pitch dark outside," right? You could object. It's a statement. It's not a question. If it helps your case, right? If it doesn't hurt your case, and if anything, it's hurting the other side because that attorney's coming off, rude or inconsiderate or disrespectful of the witness, then you have that. Just know that you have those options in your back pocket. But if they said it, if the jury's heard it, you got to strike it, or else it's out there. Okay. The only real consistently enforced rule is that leading questions cannot be used on direct examination. They can be used on cross-examination, and you see all the exceptions there. Laying foundations, examining children, preliminary uncontested matter, hostile adverse witnesses, if you're having to help a witness during difficult testimony, refreshing recollection, things like that. A leading question is one in which the attorney characterizes the fact in the attorney's word and asks the witness to agree with it, which deprives the witness of the opportunity to characterize it in his or her own way. Right? It was pitch black outside, wasn't it? Right? If you want it to be really, really dark, then that's the language you use. Right? Maybe they used in their direct that, well, it was nighttime outside. But you want to emphasize that it was really dark. Then you use that sort of loaded language in painting your picture. If the attorney questions farther and characterize the fact that is inconsistent with the evidence at trial, you could object that the attorney is misstating the evidence, misquoting the witness, assuming facts that are not in evidence at all. Okay. If a question contains not just a factual assertion, but an argumentative conclusion, right? You can object that the attorney's being argumentative. It was so dark you couldn't possibly have seen anything, could you? Okay, and these are all examples from actual cases. Would it surprise you to know that the victim had a substantial blood alcohol level that day? Did you know that the defendant injected people with drugs, performed abortions on women, had an illegitimate child, killed a woman during an abortion, was charged with a sex offense against his daughter? And a whole lot of loaded stuff in there. So you could see those, but those are not good questions. Okay, and you shouldn't be asking those types of questions to your witnesses. Questions need to be reasonably clear. You could, but many lawyers don't object to questions that are compound, or they're ambiguous, vague, or incomprehensible. That'll happen. Sometimes you'll just be talking to them, asking a question, and words will come out of your mouth, and it'll be like, what did I just say? That made no sense. Scratch it. Let's try that again. And you just ask it again. I would never impose that on an opposing counsel unless the witness really is trying to answer a question that they don't understand and they don't have the wherewithal to ask. Most witnesses will. I don't understand your question. Assuming they don't, and the question really is incomprehensible, and you see the witness up there struggling, like, maybe I'll help the witness out and object. But usually the witnesses can handle themselves, and if they don't know what you're asking, they'll tell you. They'll say, yeah, I'm not sure what you're asking. Could you rephrase it? And sometimes, like I said, you just know. Right? You just know, like, yeah, that was a horrible question. I don't even know what I just asked. So, right, on direct examination, once the question's been asked and answered, you're done. Right? If attorney attempts to go back over that, right, that is cumulative evidence, like his honor said. You don't get to do that. However, on cross-examination, you get to. Right? And you can sometimes do it several times. So, if it's your witness and the other side's cross-examining, do you object, ask, and answer?
Anybody? There's only two answers. Come on, shout it out. Pick one. Seriously, nobody's going to play on this?
It's your witness, the other attorney's asking them questions, and they keep asking the same question over and over.
Yeah, the objective that's cumulative. Or
Badgering the witness.
You can, right? And the judge may say, I agree with you, or they may say, it's cross-examination, counsel. I'm going to allow it. Right? On cross-examination, you can ask the same question more than once. But you can ask it different ways.
But it's probably not a real good look to ask it a bunch of times.
So
the jury will get the point, right? They are paying attention.
questions, right, they need to be asked in a professional manner, and a witness should be treated with respect. You don't get to embarrass, browbeat, harass, yell at, or insult a witness.
Which doesn't mean you can't be confrontational and accuse them of lying. Okay? But you got to do so in a respectful manner, right? And I don't mean respect like they deserve respect even though they're on the witness stand telling a falsehood. But you treat them like a human being, right? And not like somebody you're trying to embarrass or browbeat.
Yeah. And you're gonna have to gauge how it is you go after your respective witnesses. Right? If you've got somebody on the stand for whatever reason, because of their age or physical impairments or whatever, they're slower, and they're quieter, and they're just, it's hard to understand what they're saying. You're never going to want to be raising your voice and yelling at them, and right, that's just But you got somebody who's rude and disrespectful and, you know, you got their arms all laid out. What are you asking me, counselor? Right? It's like, why don't you try sitting up in a chair? Don't do that. The court might. But the jury sees that.
And when you're preparing your witness, right? Because that's cross-examining a witness. A witness that doesn't want particularly healthy. But somebody called that witness to the witness stand, right? And when you prepare that witness, you tell them, look, adopt the same posture, adopt the same attitude on direct as you do on cross, because you're just there to provide information, right? I once saw the chairman of American Airlines, okay, on direct examination. He's on the witness stand, he's explaining this is why we did this price and all this. Within 5 minutes of cross-examination, he was like this. And he had a real scowl on his face and was just snippy. And it's not a good look, okay? And I know that the lawyers that called that witness had spent a lot of time with him because he was one of their key witnesses. And yet, well, he's not used to people like confronting him and asking him direct questions and whatnot. And so whatever that preparation went out the window. So at trial, if they're a witness, they're going to have the same attitude on direct as they are on cross. That's easier said than done, right?
And something that you need to kind of keep in the back of your minds, right? Whose courtroom is this? Right? This is where you, this is your case. It doesn't matter who comes in there. Right? The head of the airlines, or a brain surgeon doctor, or a chief of police. It doesn't matter, right? This is your area. You're the expert, and you control your witnesses as you see fit. You control the other side's witnesses as you see fit. If it's my cross-examination, I don't care who they are. They're going to answer my questions, or I'm going to use the tools that are afforded to me to shut them down, right? They're not responsive, I'm going to move to striking. Right? They're going to answer the questions I lay out before them, regardless of who they are. So, for the expert, this courtroom is your home field. Right? I wouldn't go into an operating room and tell a brain surgeon, hey, you're doing that wrong, right? They're not going to come into my arena and tell me how to do things. Okay? They'll try, and having the confidence in yourself and the ability to know the rules, knowing that it doesn't matter how they respond, you have weapons at your disposal to deal with it, should let you rest assured. Doesn't matter. What are you saying? This is the head of UCLA neuro unit. Okay. Yeah, he knows his neuro stuff, but I know how to cross-examine him, right? And I know the rules of court. So just kind of keep that in mind. I see people who get intimidated by witnesses, and they forget that what their role is, right? And then they start kind of shrinking in stature right there in front of the court, in front of the jury, and letting the witness kind of take control of things. Okay? Just telling you now, I know when you're younger it's hard to do, but practice it, and as you gain more experience, you'll gain more confidence, and know that you can control any witness. It doesn't matter who it is. Okay? When they come into your court, right? As long as you know how to do it. And of course, on direct examination, right, they don't get to testify in narratives. And on cross-examination, right, they don't get to volunteer extra information. If they do, strike it. So non-responsive to my question. Okay? And you can control how that goes forward. And you'll get the feel for it too. On narrative, sometimes I'll ask an open-ended question and my witness is talking and maybe they're kind of going off track and getting into stuff you don't want them to get into. I'll stop.
You stop them, don't let the other lawyers stop.
Right.
And maybe the way to do that, like, oh, hold on just a second. Let me ask you another question.
Yeah.
Right? And sometimes it's because the witness is really nervous. They're not used to testifying, right? In front of a room full of strangers about something that may be very powerful, emotional, an important event in their life, right? And so sometimes you gotta help them slow down. Remember, the court reporter's gotta write down everything you're saying too. Slow down, take it easy, and one way to do that is to ask little bite-sized questions, right? And so if they want to go all over the place, well, let's just do this one step at a time and ask you some more questions. And if you do that, sometimes it helps witnesses to calm down and okay, but even then, and I saw it this morning, witness is emotional. She's a victim of a crime. She's upset about it. That's her former boyfriend who's sitting at the counsel table. She's upset, and she's throwing out all sorts of stuff that wasn't really responsive to the question. And so if you're the person that called that witness, you got to help them, right? This is your witness. You want them to come across well. Help them. Just okay, I get it. You got a lot to tell us. Sometimes if the judge is like me, they'll try to help the witness too. But look, I understand you have lots of stuff. We want to hear what you have to say. The easiest way to do that is just listen to what the lawyers are asking you and answer the questions. And after a while, hopefully they'll get calmed down and just try to answer your questions. But help your witness, right? Help your witness. Do bite-sized questions. Go back if there's something that you really need to make sure it was clear. Say, I apologize, but I want to make sure that something's clear. Boom, and get the point that maybe got lost in the longer answer.
Okay, so let's go ahead and look at the example there in the book. Not the first problem, then we'll just go through the example there. And hopefully you guys can start picking up and understanding some of this stuff. All right, so you've got a prosecutor. He's conducting a direct examination. Wally, where do you live? Objection, leading. Right? Is that a leading question?
What answer does that
What
suggest?
is a leading question?
It's one that suggests an answer, right? What answer does that suggest? Doesn't.
Right?
It sort of assumes facts not necessary that you live somewhere.
Right, so the judge most likely ruled in this manner because the question was not leading. It was just, it didn't suggest an answer, it just asked background information. Where do you live? I live on the corner of 4th and Overland Street. What happened on July 10th at 7 p.m.? I saw Johnny B. Bad shoot and kill Louis Ratatouille. Did Johnny shoot Louis with a revolver? Objection, leading. Is that leading? Right, it's suggesting what?
That it was a revolver.
That it was a revolver. Right, the shooting's already come in. Okay, it's already come in, so that part's not leading. It's not suggesting that he shot him, but it's a revolver part that is what's leading. Right, and so the judge sustained it. So Johnny shot Louis dead. And after the shooting, in which direction did Johnny drive away and where did he hide the gun? Right, defense counsel, objection on 3 grounds. Asked and answered, compound, assuming facts not in evidence. So before we get to the judge's part, right? Is this an ask and answer? Kind of the first part, right? So Johnny shot Louis dead. Yeah, he's already testified to that, right? Is it a compound question? Is it asking more than one? Yeah.
Yeah.
He shot him dead, right? Which direction did he drive away? Where did he hide the gun? Right? Then a whole bunch of
I
questions.
have a question about compound questions. Does it have to be two or more in a single sentence, or could it be one right after another?
It's gotta be one,
Yes,
it's gotta be in one question. So if you're throwing something in that's got, yes, you can ask 4 sentences that have 3 questions, sure.
But it's generally you're asking it without a response from the witness,
Right.
right? And is it assuming facts, not in evidence?
Yeah.
Yeah, right? It's assuming what?
That the gun was hidden.
Gun was hidden,
That he drove away.
that he drove away,
Yeah.
right? She, well, Wally hasn't testified to those things yet. So that's assuming facts that aren't yet out there. Okay, so those are the types of things that you need to be on the lookout for. So we've got 7-10, returning to form objections. Right? We need a plaintiff's attorney. We need Alfreda. We need a defense attorney. And somebody in the back row needs to be the judge.
Who has to be the judge? Anybody?
I'm in the corner, so whatever, I guess I'm like, for whatever role.
So,
Who wants to ask the questions?
All day.
Okay.
So
Where's our plaintiff's attorney? Who's gonna make the objections?
Okay.
All right, there's the defense
And,
attorney, who's
Trish-
gonna be our witness?
You'll be
All right.
or you got it?
Okay,
Okay.
Okay.
and who's our judge? All right,
All right.
okay, here we go. Plaintiff's attorney.
Would you state your name for the record?
Alfreda Cohen.
You live in San Francisco, right?
Objection.
What's the grounds? What's the grounds?
On the grounds that
Come on, Mr. Defense Attorney.
it is, argument.
Ding, no.
You live in San
Leading.
Francisco, right?
Sounds like it's suggesting an answer, yes. So, objection leading. Your Honor?
Sustained.
But Your Honor, this is foundational.
Right? Plaintiff's attorney, what would you say?
Do you live in San Francisco or somewhere else?
Okay, to the objection.
No.
All right, we've got
How
an
do you get there?
objection.
We got an objection, it's leading. Right? What are you gonna say? Why is this a proper question?
Because they haven't answered if they live in San Francisco.
Not exactly responding to the substance of the objection. The objection is it's leading. You're just gonna give up and let this defense attorney bully you like this? What are you gonna say?
When do you get to use leading questions on? Well, really, you've got 2 responses, right? Number 1, you argue it's not leading, if it's really not leading. Or you argue why, in this situation, you should be allowed to lead. Right? And we went through that whole laundry list of exceptions.
Okay, so this is clearly leading and suggests an answer that yes, you live in San Francisco. So you're not gonna get very far in that. But what do you say? Why is it okay to ask a leading question like this? Preliminary stuff, foundational stuff? Really, is there a big dispute over where the witness lives?
No.
So,
So you would say it's foundational.
it's foundational, it's preliminary, Your Honor. And Judge? You got 2 choices. Sustain, overrule. What's it gonna be?
Sustained.
All right, there you go. Now, Lance
Do
attorney.
you live in San Francisco or somewhere else?
Defense counsel?
Objection.
Good. What's the grounds?
It's leading,
Okay, what answer does it suggest?
where do you live?
That you live in San Francisco, right?
Right.
Hasn't really fixed it.
Has it injected any other problems in there?
What's it? Is that a combat question?
It is a compound question, right? And,
Because it's sort of asking two questions, right?
and you could, it's not your best objection, but you could object that it's still assuming facts not in evidence,
They live anywhere.
right? So this stuff happens in the courtroom. Like
Real
that,
life, very
Like that.
quickly, yeah.
okay? So you've got to be able to listen and hear these things and recognize the cues for what they're saying to object. Because guess what? Do you live in San Francisco? Yes. What happened on you? Well, objection, that was
A
leading.
little late, yeah.
I'm already on to the next question.
Yeah.
Right? If you're not on the ball when that question's asked, and the witness is just going to answer. You live in San Francisco?
Yes.
Yep. Okay, boom, on to the next question.
So in this case, on this leading question or compound question, would a judge sustain that then, or just overrule to move on because it's not that big of a deal, you know, like saying you live in San
Yes.
Francisco or somewhere else?
Yes, the judge would do one of those
Like
things.
just say overruled because
A judge would
it's
do
gonna
one of
come-
those things.
this is gonna come in anyways.
Yeah, a judge would do one of those things.
Okay.
Sustain it or overrule it.
And,
Well, no, I'm
and you,
saying-
No, and the answer is, yeah, they do one of those things. Some judges would do one, some judges would do the other. I might do one on one day and somebody else on another day.
some judges will say, I'll allow it. Yeah, it's leading, but I'll allow it.
Yeah.
Okay, right? She said it was, it's just foundational. Okay, yeah, it's leading, but I'll allow it. Okay, right? It's not a big deal. It may, or the judge might say, no, that's leading, sustain. Right? Counsel, fix your question. They tried to, right? But the same issues are there. Right, so what can you say at this point? Now you're still asking a leading question. Now you've injected a compound question, right? What can you argue?
Let's say it's important to you that you get in this thing about the witness living in San Francisco for some reason. What do you say? Or do you just give up?
You know, you would just say that you establish.
Oh, you just had your second, you've asked 3 questions, and the latter 2, not the way you state your name, and the last 2 have gotten objections that were sustained. And for whatever reason, you wanted to get in the record that this witness lives in San Francisco, so what do you do? What question do you ask? How about, where do you live? Leading? Of course not. What's the answer? In San Francisco. There we go. If you want to really be a pain in the ass about it and like show the judge that you know how to ask a truly non-leading question, you say, where, if anywhere, do you live? Everybody see why that doesn't suggest an answer that you can live anywhere? Yeah. That, by the way, I don't recommend being a smart ass with a judge. But seriously, the easy way is just like, okay, where do you live? And then when you get the answer, San Francisco, you look at the other lawyer and go, really? It took 3 questions to get that? You know.
So, but this example is a good example of what you'll see in real life, right? Where does the plaintiff's attorney go? Right? The plaintiff attorney goes on to another issue.
Yeah.
They never even get into evidence where this witness lives, right? Sustained.
No, I give up.
That information never comes out. The witness never answered that question. So, and you'll see attorneys do that. They'll ask a question, it'll get sustained, and they won't know how to fix it, right?
And a couple of observations about this. One, God damn it, if you wanted to, if it was important enough to ask about it, fix it. Don't just give up, right? Find a way to ask the question and get the information that you wanted to get in. And send a message to that smart ass lawyer at the other counsel table that you're not gonna buffalo me, dude. You make a bunch of objections, eventually it's gonna get in, so just give it up. And I'm sorry, I interrupted you, counsel.
No, right, you've got to just kind of keep in the back of your mind, That's why it's so important. If he says objection, sustained, your response should be on what basis, Your Honor, right? Because
Especially where you got an objection on 2 or 3 grounds.
right, because you haven't heard what the basis of the objection is, okay? So if they say leading, you know what a leading question is, so take the fact out. That's how you fix it. Don't suggest the answer, let the witness give you the answer.
Because after all, what did you already just do? Suggested the answer. Unless a witness is a total dolt, they'll remember, oh yeah, I live in San Francisco.
If you're asking a question that's compound and it's sustained, you know, oh, that's
Break it.
2 questions, break it up into 1. If it's argumentative, change your tone, right? If it's assuming facts, not in evidence, take the facts out of your question, right? You've got to understand how these objections play out and what your response is, right? And in any case, whatever the objection is, you always have at least 1 response. Usually you have at least 2. Now, if somebody objects leading, you argue it's not leading, assuming you can in good faith. Or if it is leading, you argue that there's an exception to it. Here's why you should be allowed to lead in this situation. You know, and the same thing. Whatever the objection is, you've got to know what the basis is, and then it's just automatic. Here's how I fix that.
And by the way, don't assume that the judge will actually answer that question. Because if the judge really wasn't paying all that much attention, it's like, I sustain counsel.
Okay.
And then you gotta go try to ask any question.
This seems like one of those examples that you were saying where, I mean, pick your objections, pick your battle, pick your
Sure.
objection, because this is just, unless you're trying to establish residency in San Francisco versus like Oakland or something, right? Where you live because it's important material fact of the case. It's just like nonsense to keep objecting to that.
Or, that this lawyer's never asked a question in court before, and you just wanna mess with her, right? Because if you just wanna mess with somebody, and they can't even get in where the witness resides, how are they gonna get in anything important?
Oh.
No, lawyers don't really with each other like that, do they? You bet they do. Now, Mr. Nolan would never have done that. I certainly never would. No. But lawyers do. And why would you do that? If your adversary, why would you do that? Because you throw your adversary off stride. Now she's worried about even getting in the residence of the witness, for crying out loud, let alone like important stuff. And maybe she'll get flustered and forget to ask something that she should have asked. So, yes, absolutely, by all means, pick your battles. If Professor Nolan is asking the witness that, give it up. Well, what's the point, right? Somebody else that you might throw off stride, sure, mess with them.
Okay.
But if it becomes obvious to me that that's what you're doing, you're going to regret it.
Plaintiff's attorney, you're up.
Where were you on the night of June 1st at 9 p.m.?
Objection.
What's the grounds?
Leading.
Okay, now wait, Judge, before you rule, what facts is this suggesting? Why do you think this is a leading question?
What's the answer that it suggests?
Was there? Oh, according to speculation.
Well, you just answered the objection.
Yeah, assuming they know.
Suggesting an answer. That's on the night of June 1st. They were somewhere at 9 p.m.
Okay, and you think that's leading? Okay.
Not
Generally, a leading question can be answered yes or no. Right?
I don't think this is a leading. Am I supposed to respond with what's?
Yeah.
Yeah, you were
give us
supposed
the
to make
grounds.
an objection, and you said
And you
leading.
give us the grounds, right? Objection, and then
So,
you
okay,
give what's your
scratch
ground.
leading. You just said it's not leading. So now what objection do you want to make?
Remember, we just went through all of those potential objections, right?
So it's assuming facts on it.
What fact does it assume?
That he was somewhere on
Well, I think unless this person is a really young person, like a baby, I think they probably were somewhere on June 1st at 9 p.m. So I think it's fair to assume that they were somewhere. But does it suggest that like they remember where they were at that time? Anybody? So it sort of assumes that they actually remember that? Everybody see how that assumes that the witness remembers?
So, just as a something to keep in your mind, as you're questioning your witnesses, you've got to build the story, right? At this point, we don't know whether San Francisco was important or not. Maybe it wasn't, right? Sometimes you just ask foundational questions just to let the witness kind of get comfortable on the stand, settle down, and let the jury know a little bit about them.
Yeah.
Right? Well, Mrs. Smith, what do you do for a living?
Yeah, letting the jury know something about your witness is a good thing, and to have your witness stand up there and sit up there and answer questions about stuff that they know really well, like what they do for a living and where they live and what kind of education they have or something, helps them get comfortable because they're asking about something they actually know about.
All right, one of the things that I love to do whenever I was asking about a particular incident is I would bring their attention to the date in question and ask if they remember. I'd like to draw your attention to June 1st of 2018. Do you remember that date? Yes. Right? Where were you at 9 p.m.? Right? Now, they've already articulated, they remember the date in question and it's specific. I'm not suggesting that.
How are you going to object to that question? Or those questions? Anybody?
Suggested.
Not really. Right? I mean, if you can't call the witness's attention to a particular time and say, do you remember where you were? I don't know what question you possibly could answer.
Right? If I just asked them that date, where were you? What objection would that draw?
That's back to this question. What's the objection?
One perspective. Or suggesting.
It assumes that the witness remembers where.
Assumes, yeah. And right, sometimes if you leave the time out, you'll get an objection as to vague.
Yeah.
You
remember where you were on September 17th? I mean September 18th, 2018? I was in a whole bunch of places. I was at the Larson Justice Center. I was over in Rancho Mirage. I'm in the California Desert Trail Academy. I think I was at Taco Bell. So I was at a bunch of places. So it sort of depends on the time.
Right. So you've gotta try and narrow it down, and you just learn from experience, right? But knowing that you are building on that, right? Okay, you've made your objection. Your final objection is
Assuming facts on.
Assuming facts on an evidence. Counsel, do you have something to rebut that?
You'd say, do you remember where you were June 1st?
Are you responding to the objection? You're rephrasing your question, so you're giving up, right?
Well, you're not giving up if you're rephrasing it and putting that in.
You just give up on your question.
If the judge asks you to respond, either respond to the objection as to why you think the judge should overrule the objection, or just tell the court, Your Honor, I'll rephrase it. Right? If you recognize that you've asked a question, right? You live in San Francisco, right? Objection leading, Your Honor, I'll rephrase. Where do you live? Right? And then you look at the and they say San Francisco, right? And then it's just, they look silly. If you want to rephrase, that's your response to the court. Okay? But it just acknowledge you are, what you're doing is you're acknowledging that your question is bad. If you don't think it's bad, then you respond to the court why you don't think it's an objectionable question. Okay? He's saying it's assuming facts. Do you have a response to that?
Well, is it assuming that I know what I guess he says is vague, or it's assuming?
No, it's assuming that the witness remembers where they were on June 1st at 9 p.m. Right? Now, if you want to tweak the other lawyer, say, look, we all know that what happened on June 1st at 9 p.m. is important. And so can't we just like cut to the chase and ask about it? But if counsel really wants to object to that, Your Honor, I'll ask a preliminary question. Do you remember where you were on June 1st at 9 p.m.? Answer, yes. And then you kind of like, and go on.
Judge, you got a ruling on that?
Sustained.
There you go.
Okay.
So now what?
So now you rephrase it.
Apparently here it was sustained or overruled. Because we get an answer from the witness. Witness, answer.
I was at the Burger King having a candlelight dinner.
Romantic dinner at Burger King. It doesn't get better than that, does it?
Okay, now let's stop right there. Defense attorney, I'm gonna pick on you real quick. Question was, where were you June 1st at 9 p.m.? Yeah, that was her question. Where were you June 1st at 9 p.m.? The response was, I was at Burger King having a candlelight dinner. Could you object to that answer?
Remove the strike part of it?
Strike portion about having kind of.
Yeah,
That's
that doesn't
not
say where you
responsive.
were.
That's not responsive to the question.
That's-
Where were you?
Okay.
I was at Burger King.
Yep.
Anything else is extra, right? If it matters, object, non-responsive, move to strike. Okay, and then Coral said, yeah, strike everything after
I was
King.
at Burger King, yeah.
So, just know that, see, that's a type of an answer that you might not think anything about, but it's adding information that she didn't ask for. Okay, I know it's not in the book, but I want you guys to see that. That's how part of that was non-responsive. And this isn't an all or nothing,
Right.
right? Where either the whole answer comes in or the whole answer goes out, right? You can piecemeal it. It doesn't have to be the whole question or some of the question, right? If your question's compound, well, okay, just ask that first question again. Right?
How would it be, I thought non-responsive is when the witness isn't answering.
Yeah.
It wouldn't be narrative.
Think about this. Having a candlelight dinner, is that responsive?
I thought it would be.
Drop the first part of it. Where were you on the night of June 1st at 9 p.m.? I was having a candlelight dinner. It doesn't say where you were, it says what you're doing.
Okay.
And narrative
I thought-
would be,
Going
I was
on
at
and on
Burger
and
King,
on, and
I was
I
having
would.
a candlelight dinner. Oh, it was so nice. We had a tablecloth and the Whoppers were there. I got cheese this time and we got chocolate
Yeah, those chicken
cheese.
finger fries.
Oh, the chicken finger fries and, and we know the manager actually turned the lights down in our corner and it was so nice. Right now you're that's a narrative.
And there were free
Right.
refills of the soda.
You're going on and the question was, where were you? Right, so the narrative is just, you're being non-responsive, but you're being non-responsive in telling a story, not just giving one simple fact. Okay? So, at Burger King having a candlelight dinner, plaintiff's attorney,
What did you see and hear at that time?
Objection, compound question.
Ooh, that's a good one, huh?
Overruled.
That's not two questions.
Yeah, but it's not two questions, it's,
It's not two questions?
what did you see?
You can argue that it's two
What
questions.
did you see? What did you hear? Aren't those two questions?
Yeah.
Okay, yeah,
Yeah.
you're right. I probably overrule that too.
You could answer both of them at once.
Yeah.
But what do you know, really make them separated, say, what did you see and what did you hear? Two separate questions, that's mine.
Oh, and so if you really want to be like a pain in the neck and you get a sustained on that, what did you observe? It's only one question.
Right, so that's a, maybe a technical violation, but it's also one of those things that's kind of,
Yeah.
right, what did you perceive? Right, you kind of ask them what happened. Yeah, that's kind of what you're asking, but
You could say, you could object to, do you remember what you saw? As soon as facts not known. Yeah, right, okay. Probably not. Anyway, so judge overruled the objection. Answer?
I saw the defendant selling goods to my competitor.
So you saw the defendant selling goods to someone else?
Objection, asked and answered.
Sustained.
you got a response to that?
Before the judge ruled?
Well, it was asked and answered, so how would you argue that?
Maybe you don't, right? If it was, and look, sometimes you'll ask a question, they'll make an objection, and you're like, yeah, that's an objection, you're right. But, right, if you were going to, right, you want to be able to just think about what types of things could you say, right? Is it ask and answer? Kind of. She's already said she saw the defendant selling goods to someone else. Maybe you're using that as foundational to set up who the someone else is, right? She's already said competitor, right? So you saw him selling to someone else, right? Maybe something like that. But you're right. It kind of is repeating what the witness just said. Okay, so let me change that. Right, witness said, "I saw the defendant selling goods to my competitor." So you saw the defendant selling goods to someone else. Then what happened? Right? Is that asked and answered?
Like prefaced it. Oh.
No. Do you have an objection to that?
Making a statement, objection.
Kind of making a statement,
Yeah.
right?
Counsel,
Kind of making a
speech is
statement.
fine.
What happens if they do that every time, right? Everything the witness says, some attorneys do this, right? The witness will say something and they'll repeat what the witness
They'll
said,
be like, so you were at Burger King. What did you say? You
right?
saw it good. So after you saw him selling goods to the competitor, what did you do?
So sometimes the court will just tell the counsel, stop
Cut
repeating
that
what the witness says. Let me ask you, defense attorney. So you saw the defendant selling goods to someone else. You see any other objections to that? Just on its face.
It's leading.
It is leading.
It is leading.
Right, that's a leading question too. It is asked and answered, but sometimes because the witness said it before and you say it again, people forget that it's still leading. You're right. You're still suggesting facts to that witness. So yeah, good catch on that. That's a leading question as well. Plaintiff's attorney.
After you saw the defendant with your competitor, what happened next?
They left and I went to my office. Later that week, I saw the defendant's sister. Now she's in business with the defendant and
Objection calls for a narrative answer.
Overruled, not timely.
All right.
Okay, now, you objected, calls for a narrative answer. That's an objection to their question. Right? Judge said not timely.
Okay, sorry.
So what else, what other objection could you make?
Objection, non-responsive.
Non-responsive and objection narrative. Right? The witness is giving a narrative.
It's a narrative,
So-
even if the question didn't ask for a narrative.
So if it's a narrative, then he would probably sustain it if the witnesses keep,
I don't know, this judge never know.
right? He's letting everything in.
Oh, except that San Francisco thing.
Okay, so, she said all that, you object narrative,
What's
he
what do you say
sustains it,
next?
then what do you do?
Your Honor, motion to strike the.
Yes,
That's
everything
what we got
after they left and I went to my office.
You guys see that? If you don't, that stuff is still in evidence. Okay? So even though you objected and it was sustained, it's still typed down on the record, and if this thing goes up on appeal list, it's still there, you've gotta strike it. Okay? So every time a witness gives an answer that you don't want in, either it's non-responsive or it's narrative, you gotta move to strike it, right? If the words came out of the witness's mouth, you gotta strike it, or else it's not gonna work. Okay? So, right, this stuff it can be difficult at first, okay? But you gotta keep in mind, when you're in court, you're not gonna have a chance to read this. You're not gonna have a chance to see, what did they say, what did they not say? You've gotta really focus, and you've gotta pay attention, and you've gotta know the clues, okay? What makes something leading, right? The suggestion of what the answer is, right? So if you hear a question that does that, objection leading, right? If you hear, it's almost reflexive, right? What did somebody say? Objection, hearsay, right? And it may not be hearsay, right? There may be tons of exceptions, and maybe it's not being offered for the truth. And we'll get to hearsay eventually, but that's just a clue. Like you hear, what did somebody say? Objection, hearsay, right? Because they're talking about what somebody else said, not what.
Or, without getting into it too much detail, what they said at a different time. What did you tell the police is just as much culture hearsay as what did somebody else say.
Okay, so
I digress.
this stuff, it takes practice. It takes effort on your part to see it, and it's easier when you're looking at it to see it and you have time than it is in court, right? And you'll see, as Honor could probably tell you, sometimes they'll put like brand new DAs that maybe they're still in law school and they're just a clerk, and a clerk that's with the public defender's office, and they'll say, you guys go do something together. And you just sit back and you watch them object and stuff. And it's hilarious, and they don't know.
Yeah.
Right. My very first trial as a law clerk, you're supervised by an attorney. Okay. And my attorney sat in the back corner of the courtroom, and I was up front at a podium as I was asking questions. She was kind of there in my periphery, and she had a little card. And that just told me to object. Didn't give me a basis. It just was telling me object. Right. And I had to figure out, okay, what do I object?
Objection.
Objection.
Leaving.
Right?
I have a question regarding that. What if you don't know right off of that which objection is the correct one? So you do pick maybe a go-to one like leading, but he's going to give you like 10 seconds to think of the correct one when the other attorney. Is that okay?
Okay, but what if the judge just overrules it? Objection leading, overruled.
I mean, calls for speculation.
Okay.
Right? So some judges rule, right? Some judges don't let you respond. Some judges will call you out for a response. Counsel, what do you say to that? So you got to be, and some judges will help you out. I've seen a judge say, sustain, not on that grounds, but on this other grounds.
Yeah,
Okay? Yeah.
yeah,
Sometimes they'll do it.
yeah, don't ever, if you're a judge, don't ever say overruled on that ground, because then you know what happens? The lawyer starts throwing everything they can possibly think of out, like, I know there's some good in there somewhere. You know, I don't. So, I try never to do that. Unless there's a real obvious objection that the lawyer somehow just like overlooked, that really is a good objection. In which case, I might do that just to kind of say, you got it somewhere, but you've got to think about it. But seriously, if you do that, then they just like throwing everything out. It's not pretty.
Okay, why don't we take our break and we'll come back in and we've got one more.
One more.
To have fun with.
Are we having fun yet?
I hope so.
Yeah, we're having fun? Okay. It's harder than it looked.
I know, that's what's
But
deceiving.
it gets easier. And I say that it gets easier. And also you'll see there's experienced lawyers, right? People that have been lawyers for 10, 15 years that just, you can tell they're just winging it. They're just throwing stuff out there because they don't know the objections still. You know, as long as they've been an attorney, they still don't know what the objections are. So.
And sometimes you just know it's objectionable, but you just can't think of why.
Can't write.
If worse comes to worse, just say objection, and maybe the judge will sustain it, just because, yeah, it is. But if you do that, you gotta come up with some grounds that just says on what ground.
Yeah. You need grounds? I got an objection.
I got a bird award one time for that. Lawyer says objection, I said, on what grounds? She said, I just object. I said, well, it's very persuasive, but overruled. I got a bird award for that.
Nice.
Yeah,
You only have one student? She's my
right
favorite.
at the moment,
Oh,
Yeah.
just say next time.
she's our favorite student. Nobody else in the room, she's our favorite student. You kicking Tort's butt?
Yeah, it's been a good, we had a good class that were responding and stuff. And understanding.
We're doing objections on the form of the question and stuff. Yeah.
Have you stopped beating your wife?
No,
Yes.
I have not. Because you cannot stop what you haven't started.
Yeah, I don't get too many of those in the,
Probate?
I never got too many of those in the Civil War. The only one I wouldn't allow and would object myself is if they asked a witness, that another person's lying.
Yes, I always
I
did.
object, I said,
And you'll see lawyers like come, was that answer the truth? Right? You heard Mr. Hopp say X, Y, Z. Is that answer the truth? And that's pretty close to, are they lying?
I wouldn't allow that. The jury,
How about-
the
was
jury
that-
determines the
How
credibility.
about, was that answer accurate? Was that correct?
You know, if I might allow that under certain circumstances, maybe of an expert or something. And another thing,
Because you do need to allow a witness to say, hey, that what they said, that wasn't true.
that's not what happened.
Yeah. That's not how I remember it.
Yeah, that's you, I don't mind it, you talk about the facts.
Judge Kavanaugh, was that the truth?
And you know what, I had, most people, a lot of attorneys say, that wasn't the question I asked, which I find to be offensive.
It's a little argument.
And the way to do that is to say, my question was over, I asked you this.
Or just repeat the question exactly. And it becomes immediately obvious, they didn't answer that question.
Can we run back, this is a critical question, I can't remember what I asked.
Yeah, well, there's that problem. There was a guy I worked with ages ago, a partner at Paul Hastings. His name was Ollie Green, and he was great at being able to repeat the question exactly if the witness didn't answer it. And he can do it forever, right? And if you watch that, it's really effective because the witness is evading, same question, same question. It's real clear they're not answering the question.
And the jury hates it.
Yeah.
They know you're hiding something.
Just give it up.
It's so much easier, because they only hear it one time instead of 12.
Right. Well, and if you act like you're hiding something, then they think you're hiding something. If you just sort of give it up and act like it's no big deal. Dolan's really good at that, you know? Where he gets a ruling that he does not like in the United States, he pretends that it's just fine.
Thank you, Robert.
Right. Thank you, Ryan. I appreciate you excluding the most crucial evidence that I had. I'm going to go out and hang myself afterwards. I'm going to act like everything's okay.
What's the chance you'll get a civil trial?
I've already got some assignments.
Yeah, right.
Yeah. Both of the ones that I have got assigned to me are assigned to Riverside.
Are they downtown cases?
Yeah.
Well, you know, everything's going downtown now, right, for a trial.
The juries are open arms.
Yeah.
They're not happy.
Yeah, both of them are in front of Judge Vineyard.
He's just the
He's a master counsel.
master counsel.
Oh, okay.
He won't try.
He's
a good
not
trial.
trying to case, but you're going out.
Yeah.
And you may get assigned down here.
Well, they endeavor to keep the desert cases.
That's what they say. You know those judges. They say that.
They don't mean it.
They don't mean it. You guys don't care where the case came from. They're not the ones driving.
So have you ever tried a court trial?
I guess the closest I came, which was, I thought I was having a court trial on that UD matter.
You mean with me?
No,
In front of Johnson?
in front of Johnson.
Yeah.
Right, it was a court trial, but I watched two UDs that had gone in front of me. And basically, the attorney standing there, their client standing next to them, and they're just, right, there wasn't any.
Did you enter into a written lease dated such and such?
Yeah, there was no take the witness stand, and like everybody was sworn in mass.
Yeah.
And
Anybody going to testify today? Stand up.
yeah. So, it was not what I expected, but
Just as a run-of-the-mill routine
yeah.
cases.
So,
Was it the same attorney
it was.
that showed up?
Who was it?
Her last name was Abadi.
Body, yeah.
She's from Glendale, and she was.
So when I was a relatively young lawyer, Dave Barron
Oh.
sent me to downtown LA to prosecute an unlawful detainer case on behalf of one Julius Buckner against Sylvia Kokomaderchi, who had let the plate glass insurance lapse on her dress shop because her goddamn husband left her and went back to Iran. This was my assignment.
Who are you working for?
Best in Crete.
Was Dave Barrett?
Oh yes. And so I'm sent
Oh,
downtown.
was he in
to
the
do
Palm Springs office? Was
Yes.
Tom Slovak?
And I was sent downtown in LA to do this because Mr. Buckner was a bit of a sexist pig, and he didn't like the fact that her husband left her, and he wanted to get her out of her property, out of his property.
Were they all Iranian?
What?
Were they all from Iran?
I don't know. That's what this tenant was. And so I'm going, do you know what a mill, the downtown UD calendar is like? Oh my God. So we got sent out to trial before the Honorable Warren Deering. This was Judge Deering's last day on the bench. His last case is to kick Sylvia Cocomaderci out of her dress shop. Which he did.
Which he did.
And I didn't feel real good about my job that day, but I had to do it, and I did it.
How long were you at BB&K?
A couple years.
And what years are those?
88 to 90.
So Nethery was there at that time.
I worked for the Honorable Martin Nethery.
Yeah.
D. Martin Nethery, sorry.
D. Martin, yeah, so he and I tried the Desert Rising Country Club case together.
What was that about?
There was a guy there named Mr. Mahoney that they kicked out of the club.
Yeah.
And
And
he
he was
had
upset.
Hayho, the developer, and I had
Yep, Jim Hayho.
Tim Hayho.
Which sounds an awful lot like Hayho.
Yeah. And I think I had Desert Rising Country Club, so I had the country club and he had Hayho.
Yeah.
Yeah. And Leonard Bach was.
Oh, Leonard Bach.
Representing Mahoney.
That guy tortured me on a case. He's killing me on this case. Oh man, I hated that guy.
It was Bach and Harlow.
Yeah. And look what Scott Harlow's doing these days.
I don't know, he's in Canada and he can't come back into the United States.
He is disbarred, I believe. Anyway.
How long have you been practicing?
I joined the DA's office in '99. So going on 20 years.
Yeah. So the other day, the DA's office brought in about 10, 11 law clerks. So they graduated from law school, they're taking the bar, they're waiting for the results. And I'm looking at them going, there is no freaking way you guys have graduated from law school. Because they all look like they were 12.
Yeah.
Irwood sees them come in my office. He says to me later, oh, so you had some students in your office? I'm like, students, Rick? Those were lawyers waiting for the bar results. He's like, get out, I thought they were high school students. That was bad. It was bad. Bad. I'm telling you, it was bad. And I'm looking at them going, I know what they're thinking.
Well, who did you look up to when you were at BKK? What were the older attorneys that were the great attorneys and all that stuff?
Well, you know, it was the guys.
Bill DeWolf, Carpenter.
Yeah, I didn't deal with those guys too much. Carpenter a little bit. Mostly the guys in the desert, right? Barron, Slovak.
Well, now you're those. Now you're one.
Netherings.
Yeah.
But see, this is what I'm saying, right? These kids are looking at me going, he's ancient. And I don't feel ancient, John. When did I get old? Seriously, when did I get old? I don't remember getting old. I don't feel that old. But if you look at kids,
your mom just turned 90, and my mom just turned 90. We're kidding.
but if you look at kids that just graduated from law school, so they're 30 years younger than I am, just about. I'm old. Yeah, that's depressing, isn't it?
So, you know, Sonia Starr.
Mhm.
So, I don't know if it was the first trial, but she tried a case in front of me to give the pre-trial at Chambers, and we're walking out. And she goes, so how are the boys? And I had no idea what she's talking about. She went to school with David Cody.
Oh no! Yeah, how cool is that?
She went to school with David Cody.
And actually, I first thought this about those young lawyers are thinking that about me when I became a judge. And that was 13 years ago. And I know they're looking at me going, he's ancient, right?
Yeah, he's older than that guy.
Yeah! Oh,
And more than a decade.
it's bad. Bad. It's really bad. And you know what? It's never going to get better. They're never going to look at me and think I'm young.
Never happened again.
Nope.
And then Fujio, she went to La Quinta High School.
I believe she did.
She's local. I just don't know. She's been around for a while.
Yeah, well, she was one of those guys that they got free labor from. She tried several
Yeah.
cases before she was,
There's that whole group there for a while.
not good. You know? But she was, I mean, she was good. She worked, you know, she did a decent lawyer, not getting paid a dime.
Someone has to supervise it. I think Kevin Miller tried his first case in front of me. Oh, no, maybe it was Steady's son,
Sam Stone,
Sam.
I like him.
I don't think he was a lawyer at the time.
Really?
He did a really good job.
Yeah.
And
Well,
Sue,
he should.
Sue did a better, well, he's a public defender.
I know, but Sue knows how to try a case.
But listen, Sue, for credit, stayed out of it. And did not interfere.
Let him sink or swim.
And who was the guy that, this is attorney, he's a really nice guy from the public defender's office. And I can't remember who the DA was, but they're just, you know, completely different story.
You.
Daniel Yu.
Danny Yu.
Yeah, he's a really nice man.
He sat back.
I totally butchered his name, called him by a completely wrong Asian name, and he was so polite to me about that. I felt really bad.
I don't know if you had heard this story or not. I don't think it's a.
This can
I don't
be
think
good.
I'm talking out of turn.
But if you were.
Sam Stone applied to be at DA's office.
Yeah.
Never put on his application who he was, who his mom was. She never reached out, never called, and he never even got an interview.
So did they not know that was his?
They didn't know.
Because he goes to Stone and she was saying.
Mhm. They didn't know, and she wasn't going to intervene.
Well, it seemed
And
like
I was
it
just
okay for him.
And when you meet him, it's like, it's good.
Yeah.
Why wouldn't? Well, he never even got an interview, so they never even got to see him and hear him talk. And I remember Sue was asking, "Why didn't you tell us?"
Kids are that way, that's actually to their credit.
I don't know, that's, I would, yeah. I would, that's a better way to go.
Off the DA's office, he's good. He's going to be real good.
Yep.
As he gets more experience.
Yeah.
I coach my trial and here, and he's got a good sharp mind.
And some of those
Sees
kids that do the
issues
mock
and-
trial, I judged, one of the weekend mock trial things.
Downtown Riverside then?
Yeah, so like a semi or something.
Yeah, so you really.
Damn, those kids were good.
I know, I hated that because they're better than I was.
Yeah, wow. But what was funny about it was, I try to, you know, make a joke at the start of it to break the tension, because sometimes there's a lot of tension. And I said something about, now I know you all are not used to working when it's light outside the courtroom, right? Because they always do it at night. And some of the kids were funny because they didn't know that it was okay to laugh at a joke that the judge made.
That can be a valuable tool in trial.
So, you know, next time I'm gonna have to say, for those of you who aren't laughing, when a judge makes a joke, you should be laughing, even if it's not funny.
That's exactly right.
I used to joke that when I became a judge, my jokes got a lot funnier with lawyers. But that was okay because a lot of the jokes that I told before I couldn't tell anymore. So it's just a joke, you guys. I hope that I wasn't telling too many improper jokes when I was a lawyer. All right, problem 711.
7-Eleven. We get through this, and you're halfway there. Miss Trish, I'm gonna let you pick. You want to be the plaintiff, the defendant's attorney, the judge, or the witness?
I'll be the defense attorney.
Okay. Okay. Then, Daniel, we're gonna make you the plaintiff's attorney since you were a judge. We'll make you an attorney, and we're gonna have a judge right over here. You're the judge, and then you guys have to arm wrestle, see who gets to be the witness. Oh, nice.
So is it the winner or the loser?
Nice. All right, plaintiff's attorney.
Sorry, we're trying to put Flynn stuff on her phone, sorry.
Oh,
Okay. When you saw the defendant walk by your house at 3:30 PM on July 5th, what did you do?
Who's the defense lawyer?
I'm sorry, I was thinking about the phone. Sorry, I'm sorry. Objection, assuming facts, not evidence.
Who's the judge? And?
Sustain.
all right. You guys see that? Do you have anything you want to say to that? Are you looking at that saying, did I really ask that question?
It's foundational.
I don't know, are you buying that, Judge?
No.
I don't think so.
And you guys all see that? You see there's a whole bunch of facts in there. Okay? Why is, and I think that was a good objection, Trish. Why is assumes facts not an evidence a better objection than leading, right? Leading is when you put facts in there too, right? And suggest the answer. Why is that a better objection than leading?
I think it also sends a message to the jury that I don't know, it seems more specific.
Well, okay. Is this a leading question?
Yes.
It is.
But the leading question would suggest like a yes or no answer, and it's kind of a little more
Yeah.
open.
What is this? What
Yeah,
answer does it
this is
suggest?
open-ended, right? What did you do? Right, this isn't a yes or no, right? Now, if it had put all of that stuff in there and then said, right, then you ate a piece of cake, right? Right, it's suggesting what they did.
And seriously, if you objected leading, you can totally fix that if you got sustained by saying, what if anything did you do?
So, you guys see why that was a better answer? Because the main thing is, if you're just judging it on leading, can it be answered yes or no? A true leading question, which suggests the facts, suggests the answer, is a yes or a no response. If it's asking what, it's not really leading, even though it has all those facts on the front end. Okay, that's why I think the assumes the facts not an evidence is the better objection, and that's even if it's leading at all. So, plaintiff, take it away.
What happened at 3:30 PM on July 5th?
Objection. Assuming. I don't. I don't know why I'm objecting, because, they're assuming he remembers.
Sort of assumes that something happened too, right?
What is that objection? You assume she remembered, but you don't have to.
Well, that's kind of a lack of foundation, right? Lack of, if you're assuming that they don't remember, and His Honor has given you guys a quick fix to this, right? What's the quick fix? Question is, what happened?
Remember, do you have a memory of what happened?
Nope.
Do you remember?
Did something happen? Like,
What,
if
if anything,
Oh, good, yeah.
happened at
Yeah, that's very
3:30?
good.
right?
That's good.
That's your quick fix.
Yeah.
Right? What, if anything, happened at this
Yeah.
time?
And
So, Judge, I'm assuming you were sustaining that objection?
Well, I was going to overrule it because she didn't know the objection.
Oh,
Yeah.
excellent point. Excellent point.
Fishing for objections.
no,
you know what? That's a good rule, right?
If they don't know what they got, it's
Yep. Did the defendant have anything in his hands when, as you say, he walked by your house at 3:30 p.m.?
Objection, assuming facts on evidence. And leading.
And the witness didn't actually say that anyway.
They sustain.
Okay, what else you see there? Right? Did the defendant have anything in his hands when,
Oh, compounding.
as you say,
Oh,
he walked by his house? Absolutely. Right? Those little disrespectful little commentaries that you throw in there, remember that whenever you see something like that and you can interpret sarcasm or contempt on the part of the questioner, follow on it, right? And the objection for that is argumentative. And if you're gonna fix that, you and all your little comments.
Did the defendant have anything in his hands at that time?
Right, well, here's what you gotta keep in mind, right? Let's assume this is factually what happened, right? When you saw the defendant walk by your house at 3:30, what did you do? Right? Nothing comes in. Right, so assume that just sustained the objection. What happened at 3:30 on July 5th? There's no answer, right? So you still don't even really have any evidence in yet. So, right, when you say, did the defendant have anything in his hands when he walked by your house at 3:30, right? This particular question, as written, without any responses from a witness yet, is leading. It's assuming facts not in evidence. It's argumentative. It's all of those things. So at this point, before you go any further, how would you fix this? How would you get all of that information in?
Do you recall what happened at 3:30 p.m. on July 5th?
Sure. Right? Do you recall what happened, if anything, on July 5th at 3:30 p.m.? Yes. What happened? Defendant walked by my house. Did he have anything in his hands? Right? You see that? You see, if you're not getting that stuff in, like his honor said, break it down into baby steps. Right? Break it down into as small as you can and get every little detail out one question at a time, if that's what's required. Because at this point, right, you're 3 questions in and your witness hasn't said anything. Right? You're not instilling a lot of confidence in the jury, right? You're not building that credibility where they trust that you're leading them to the right conclusion. You need to start scoring some points. You need to get some evidence in front of them, right? Break it down. Know those little tricks to overcome each objection. And now you've asked the question, right? Did he have anything in his hands? And the answer comes in.
Yes, he held what appeared to be a glass statue.
Do you think the defendant looked suspicious or shifty?
Objection speculative.
What was the objection?
False speculation? And you're asking him to form an opinion about the suspicious objection.
Okay. Is it leading?
Yeah,
Yeah. Is it compound?
yes.
And Trish, if he's asking for the witness's own opinion, the witness wouldn't be speculating, right? You see that?
Oh, right.
If he's asking maybe, did your roommate think he was suspicious, right? Maybe at that point, well, you're speculating, how did you know what your roommate thought, right? So if you're asking for their opinion, it's not necessary, it may be an improper question, but you're not necessarily asking them to speculate. What else you got there? What other objections you see?
I think we already mentioned compound question.
If you draw the conclusion that suspicious and shifty are two different things, right? You're asking for an opinion. What else you got there?
It's leading, for sure.
Right, it's suggesting the answer. Yeah, he looks, the better question probably would be, could you describe how he looked? Assume that's the question. Is there an objection for the witness saying, well, he looked suspicious and shifty? Can a witness not say those things?
Well, that's really where an objection would be brought up. It just seems that's your opinion.
Right? But do you think a witness can't say that? Could you describe how he looked? He looked suspicious. He looked shifty. Right? If you suggest that, it's a leading question, but if you just ask a question and that's what the witness says, is that witness answer objectionable? I know we'll get to lay opinions, but do you think a witness can't say, a witness can't give their opinion, a witness can't use language that describes somebody?
So, is he assuming facts not evidence yet? Because you're saying it should be, so without asking him for how he saw it.
Well, if the question is just how did the defendant look, right? The defendant's walking by with what appears to be a glass statue. How did he look? He looked to be suspicious. He looked to be shifty. He looked to be upset, right? He looked to be sad, right? He looked to be intoxicated, afraid, right? All of those things you can say. And then your follow-up question should be, right? What was it about them that made them look suspicious? You know, he was running from bush to bush, looking around in all directions, you know, ducking down when cars drove by. But whatever it is that led you to that conclusion, right, you're going to want to describe it. But there's nothing necessarily wrong with that answer. But Judge, is that a bad question to suggest it?
The question that this question?
Yeah.
Sustained.
Yeah. That's a leading question, right? That's suggesting the answer.
Yes, definitely.
All right.
Okay. That says if the objection is overruled.
No.
All right. So, no. Now you've said that. What are you going to do, Trish? You just got your objection sustained and the witness blurted out an answer.
Oh, motion to strike.
You better ask. you better get the judge. Right? Do you see that? Because if you don't strike it,
It's still
it's still in there. Even though you objected, sustained, and the witness then blurts out that answer. Right? You better strike it or else it's in there. Okay? Plaintiff's attorney.
So where were you when you saw the defendant?
At first, I was still in front of my house. Then I went inside to telephone the police. I was steaming. At 4 p.m.
Objection,
What's the objection?
narrative beyond the scope of the question.
What are we gonna do, Judge?
I would say, sustain.
Yeah. And then what are we gonna do? Defense counsel,
Oh, me?
move to strike everything, right?
All right, move to strike. Do I have to be specific when I say move to strike anything past this first sentence, or do I?
Sure.
Okay.
Sure, right? The question was, where were you, right, when you saw the defendant? I was in front of my house. That answers the question.
Yep.
Right? Anything after that, okay, you can move to strike. Okay, and if you aren't sure, right, and you haven't written the answer down, right, you say something like, Your Honor, could we have, Madam Reporter, read back the last response?
From the start, and then I'll tell you what.
And then they'll read it, and then you say,
Everything after that.
everything after that. Get that?
Yeah.
You guys understand this? It's just something you gotta do. Okay, you gotta play all parts, right? You gotta read the question. Okay, how would I object to this question? Okay, here's my objection. How would I get around this question? Right? How would I fix it if the judge sustained it? What would my arguments be for why it shouldn't be sustained? Okay, and you've got to be able to address all of those things effectively to be good at this. Okay, you've got to know when you're presenting your case, here's how I'm going to get this evidence in. And here's what I need in from every witness. If I need in that my witness lives in San Francisco, I'm not moving along until I get that in. Okay? If I don't need it, it's just a perfunctory question that I'm just kind of asking to set the stage and let them get to know who my witness is. Okay, it's not a big deal. Move along. If it is a big deal, you can't move along. Okay, and you've got to be able to anticipate what some of those objections are going to be. And you're going to anticipate because you're going to ask yourself, is this an objectionable question? Okay, and if it is, how am I going to get around it? Okay, and once you have that in your back pocket, you can confidently then go about questioning your witnesses. Right? If I misspeak and I ask a question that's objectionable, so what? They object, the court sustains it, I know how to fix it. Okay? And hopefully you don't do that. Right? Hopefully you're able to question your witnesses, but that being said, some people write their questions out. I'm not a huge fan of people writing their questions out, but some attorneys do, and they're effective in presenting their evidence. If you write your questions out, they better not be objectionable, right? Because they're right there, and you're putting some thought into them. The problem with doing that is you get sucked into this script,
And you're not listening to the
and you're not listening, right? And so you ask your question, your witness answers 2 questions down, right? And you ask the next question, and then you just ask your 3rd question, and they're like, well, I already answered that, right? And you weren't paying attention because you're just going through asking all this. Your direct examinations flow much easier when you know, maybe you have an outline, you know, here's the evidence I need to get from my witness, and then you go about having that conversation with them. You're talking to them. You're listening to what they have to say, and you know that you're getting in everything you need from them. Okay? If you're not listening to their responses, your questions are gonna not make sense.
And it'll be obvious.
Yeah, and you'll ask things that the witness already answered, and the jury will see that. Are
Where
you even paying attention? I'm
she,
paying attention.
where she won't get stuff in that you need to get in because you assume that they answered it.
Okay, So that's one of the pitfalls of doing that. I know, and I think they still do it today. You go into the DA's office, you're a brand new DA, they give you DUIs. Say, go try DUIs. And then they give you this nice binder, right? Prosecution of DUIs for dummies, right? And it's got every question in there. It's even got your opening statements. It's just a fill in the blank with the facts, and it's got a closing argument there. And you get these lawyers in there, and they're reading questions. And they sound horrible because they're not paying attention to what the witness is actually saying. And I've always thought, what a horrible thing to do to brand new lawyers, just give them, here's all the questions you need to ask, when you really want them focusing on the skill of getting the information from your witness, right? Because you might ask the right question, but if they don't give you the response that you're expecting, maybe you're not ready to move on to the next point. You've got to stay on that point until they give you everything. And you know what you want, so you have to ask the questions to bring it out. Okay? And being able to effectively respond to objections is very liberating. It's very freeing, right? If you go in there and you're scared, well, if they object, I don't know what I'm going to do. You're not going to be good at this, right? If you go in there knowing, well, if they object, I know I can respond to it. And if nothing else, Your Honor, I'll rephrase. You know, yeah, that was a bad question, that was leading, that was whatever, I'll just rephrase. Okay, you always have that. Okay? And you say it with a smile and you act like you, no big deal, and you just move along. Okay. So, practice this. There's other problems in here, there's other examples. I know, I believe Dean Dolan, or somewhere in the office, maybe it's over in this side office where they actually have a game. It's called objection. It's just, you practice. You know, and it gives you practice on making objections, what they are, responding to them, and fixing it. So when you got nothing else going on, and you want to practice, it's a good skill to have. Because it will carry over in all aspects of lawyering. It doesn't have to be in front of a trial, right? You could be in front of a judge on a motion, you can be in a preliminary hearing, you can be in anything. These objections can come, and being able to effectively respond to them is something that every lawyer needs, and not every lawyer has. Okay. That being said, next week it gets serious, guys.
It wasn't serious this week?
Right. Next week we go into our first rule statements, and I would recommend each of you, you're going to be reading the rules. You're going to be coming to class next week with, I would recommend you do it now, a rule statement for Rule 401 and a rule statement for Rule 403. We'll talk about them, but draft one yourself.
Yeah,
You are going to use those rule statements not only the rest of the year in this class, you're going to use those rule statements the rest of your career. These are the two most common objections you're going to get. 401 and 403, just know them. Get the rule statement, know it down pat, and right, be able to, when you get your essay, relevance. Oh, there's my rule statement. Now analyze. If you're like, oh, relevance. What's the rule of relevance again? And you're trying to come up with it. You just got to have those rules just down. 403, boom, here's the rule. Now all you got to do is analyze. Okay? Start it now. I'm going to tell you, His Honor will back me up on this. Every year when we get to the finals, somebody writes a bad relevance and
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 403, absolutely.
every time. In the final,
Which means you didn't get it right
right from the
next
beginning.
week.
Get it down now. Everything is going to be building from this point forward. Everything you learn is coming with you going forward. You've got to get this down, and somebody's going to mess it up. They do every year. Every year.
Not this year.
And
Not this year.
And we look at each other like, and we tell everybody this every year, and we look at each other in the finals like, is this really their
Not this
relevant
year.
rule statement?
Right? Not this year.
So,
You guys are gonna get relevance in 403 now.
and it's important that you write your rule statement because you've got to understand the rule and you've got to understand the concept. We can give you a rule statement. That's what the statute does. It gives you a rule statement. You got to make it your own for you to understand it and to remember it. Us just throwing it at you and say, here's a rule statement, here's what we want, doesn't work. So your rule statements don't necessarily have to be the same, and they probably won't be the same. But you've got to be able to articulate the concepts in each in a way that hits all the elements of each, and that you can then analyze from that going forward. Okay? All right. That's it.
No problem.
So everybody's gonna come with a rule statement for both of those ready, and we will be calling on you to share.
See you guys.
Thank you.
Oh, it's okay.
So I'll bring in the CDs tomorrow and talk to Sai, and if not, we can just give a CD revenue. We'll figure it out. We'll give the Sai, you know, in worst case, if we for some reason we couldn't get it.
All right, thank you.
Get one. Yeah, that's fine.
That's yours. Oh, from
Because I
Sarah.
need it, I have them on my, and I have the other. No,
Right.
it's just like, I couldn't sync it. I would get sync and then I would go to the.
Have a good one.
Thank you.
See you later.
Bye, guys.
I really needed my phone though for drive. Oh, CD player.
Oh, you're in the CD player. We'll figure it out with Sai.
Yeah, it's not like he.
So what,
you
Sai
know,
will
he's
figure it out.
needed-
Well, I also
have
have
a
a drive
drive
and a
anything
flash
to
drive.
sign.
That's the other thing too, is I can put them from my iTunes onto a flash drive, which I know you can try. But we can try with a different flash drive.
Yeah, maybe it was like.
Okay.
Yeah.
It's still gonna take another hour.
Never have, oh, yeah.
Are you doing your studying?
I don't
for
Oh,
the next one?
Yeah.
Good. I think I want to just skip over.
Get nothing free.
No, you didn't have a proper connection.
I know, so.